Thank you for tuning in to the Perinatal Legal Assistance and Wellbeing Project's training on family law. My name is Victoria Prococo,
And my name is Eleanor Barrera.
and we are your summer 2025 law clerks. As a reminder, we here at P-Law provide legal advice to your patients on issues that may be impacting their health, such as unsafe housing conditions, public benefits eligibility, employment concerns, and, starting in the fall of 2025, family law-related issues. In this video, we will define some key terms, work through some case studies, and introduce you to some resources that are important for you to know should your patients raise family law-related issues during their appointments. This training covers 3 common family law issues: intimate partner violence or domestic violence, child support, and child custody disputes.
We'll start with intimate partner and domestic violence. Under DC law, domestic violence or intimate partner violence is defined as a pattern of abusive behavior in any relationship that is used by one partner to gain or maintain power and control over another intimate partner, dating partner, or family member. This pattern of behavior may include physical violence, coercion, intimidation, isolation, or other forms of abuse to control and change the behavior of the other partner. Both intimate partner violence and domestic violence can take many different forms. Here are 4 common types: technological, emotional, sexual, and financial abuse. Each form of abuse is serious and can have lasting effects. Recognizing these behaviors is the first step toward making sure patients get the help they need. Pause the video to read more about each one in detail. Protection orders are one tool in the toolbox to help protect survivors of IPV and DV. A protection order is granted by a court and requires a person to do or not do certain things, such as staying away from, not contacting, or committing any offense against the person requesting the order. The petitioner is the person requesting a protection order, while the respondent is the person the protection order is being filed against. In DC, there are 2 types of protection orders: temporary protection orders, TPOs, and civil protection orders, CPOs. People will also sometimes refer to these generally as stay away orders. A TPO is a short-term emergency order issued when a judge finds that the safety or welfare of the petitioner or a household member is immediately endangered by the respondent. A TPO can be issued with only the petitioner being present. The respondent does not have to be there. The initial TPO is valid for up to 14 days to allow time for the respondent to be served before the CPO hearing. The court may extend a TPO for longer than 14 days if necessary to complete service and hearing on the petition, in 14-day increments, in increments of up to 28 days for good cause, or for a longer time period with the consent of both parties. A CPO is a longer-term order issued after a full court hearing where both parties can present evidence and testimony. A CPO may be issued up for 2 years at a time. It can include orders to stop harming, harassing, or threatening the petitioner, stay away from and avoiding contact with the petitioner, leaving a shared residence, following temporary custody or visitation arrangements, and even attending counseling programs. Lastly, failure to comply with a CPO can result in criminal penalties, including jail time. People in many kinds of relationships, like family members, current or former partners, or people who share a child, can file for a protection order. Understanding who qualifies and how these protective orders work is an important first step in ensuring safety and support for patients facing IPV and DV. Pause here to learn more about the specific relationships that qualify. To recap, a TPO is fast and temporary, offering emergency protection. A CPO lasts longer and follows a full court process. Both exist to help protect survivors from harm. If your patient shares that they are a survivor of IPV or DV, or that they want a protection order, please refer them to P-Law. Feel free to pause the video or review the chart to learn more.
Moving on to child custody. Custody refers to the legal relationship between parent or caregiver and child. There are a few different types of custody. Legal custody refers to the right of a parent or caregiver to make important decisions about a child's life, things like their health, education, and general welfare. Physical custody, on the other hand, refers to the parent or caregiver with whom the child lives on a regular basis. A parent can have sole legal but not sole physical custody, and vice versa. In other words, they can have the exclusive right to make important decisions about the child's life, but share physical custody of the child with the other parent. When either legal or physical custody is shared, we call this joint custody. In a scenario where a single parent or caregiver has both exclusive legal and physical custody of the child, we refer to that as sole custody. The parent or caregiver who has primary custody of the child, so who the child regularly lives with, is who we refer to as the custodial parent. On the other hand, a non-custodial parent does not have primary physical custody of the child, but may have visitation rights where they have scheduled blocks of time to spend with the child. There are lots of variations in custody arrangements that are unique to each family and their needs. That is where parenting plans can be helpful in outlining the custody arrangements of each party and their respective parenting responsibilities. So if your patient mentions having custody issues, maybe they tell you about it during their appointment, they are missing appointments due to custody issues, or one parent or caregiver is barred from accessing their child's medical records, please refer them to PLAW. Finally, let's go over child support. Child support refers to payments made by a non-custodial parent to support their child while they are with the custodial parent. Child support payments are usually intended to cover a child's basic needs, like housing, food, and clothing, but they may also be used to cover childcare expenses, healthcare, and educational costs too. The amount a non-custodial parent or caregiver must pay in child support is based on their income and child support guidelines that help calculate financial obligations based on a variety of factors. The agency that helps facilitate child support calculations and payments here in DC is the Child Support Services Division. In cases where a non-custodial parent is not voluntarily paying child support or they're failing to make their payments, a judge may also issue an income withholding order, also known as wage garnishment, which directs an employer to automatically deduct the child support amount from the non-custodial caregiver's paycheck. There are specific rules for how child support interacts with public benefits like TANF and Medicaid in DC. When a parent receives TANF or Medicaid, the district is legally allowed to use child support payments from a non-custodial parent to reimburse the cost of a custodial parent's benefits. Through the district's pass-through program, custodial parents who receive TANF benefits can still receive a portion of their child support, up to $150 per month in addition to their normal TANF benefits. Any child support payment above $150 goes straight to the district. If you have a patient expressing difficulties with receiving or understanding child support payments, please refer them to PLAW.
Let's walk through 3 brief case studies that illustrate how domestic violence, child support, and child custody can appear in subtle ways in a healthcare setting. In case study 1, Ms. Martinez comes to her appointments several times over a few months, reporting fatigue, trouble concentrating, and anxiety. She's often vague, avoids eye contact, and misses follow-up appointments. During a prenatal appointment, she quietly shares that her partner handles all of their finances and doesn't believe in therapy or medications. She also relies on her partner for transportation and doesn't have her own personal phone. Here, there are no visible injuries, but her symptoms may reflect emotional abuse and financial control, a form of domestic violence that limits autonomy and access to care. Here, it may be helpful to speak with an attorney about her rights and options for legal protection against her partner. In case study 2, Ms. Jones mentions she is having trouble affording daycare for her other children during a prenatal appointment. She says her co-parent pays child support when he feels like it, but there is no formal court order. She doesn't know how the amount should be calculated or how to make the payments more regular. Here, it may be helpful to speak with an attorney about her child support options. Lastly, in case study 3, during a prenatal appointment, Miss Roberts mentions that her ex-partner has been refusing to return their child after visits and is threatening to take her child out of the state. She does not have a formal custody agreement and is unsure of her rights. Here, an attorney can help explain her options for establishing a custody order. These cases show how legal issues often surface in everyday conversations. By recognizing red flags and knowing when to refer, providers can play a key role in connecting families to the support they need. As we like to say, when in doubt, refer it out to PLAW.
While PLAW is expanding our coverage of family-related issues internally, we regularly assist referred patients with getting connected to trusted community partners to get the legal support they need, even if it is beyond the scope of our services. We may make warm referrals to some of our partners listed here. These organizations and others provide pro bono or low bono support to patients experiencing the kinds of legal problems we've discussed today, as well as other family law matters like divorce, adoption, visitation, and third-party custody arrangements.
Thank you for listening to PLaw's virtual training about family law issues that might be affecting your patients. If you have any additional questions about the material discussed today, please feel free to reach out to plaw@georgetown.edu. We understand it can be difficult to discern whether or not a patient has a legal issue and is in need of PLaw services. That's why we say, when in doubt, refer it out to PLaw.
Please check your email for the link to fill out our post-training provider survey. Thank you for listening.